The London Arbitration Centre Consumer Guide for the Enforcement of Awards. An order for payment of money can be enforced using the procedure set out in the Arbitration Act 1996. Basically, this involves the consumer making an application to the court using a specific type of claim form, which is called a Part 8 claim form (arbitration). The claim form must be supported, which means accompanied by a witness statement, a draft of the order sought, which is usually straightforward. Trader pay the consumer X amount, and the court fee. The consumer will also be required to produce to the court evidence of the arbitration agreement. You may wish to contact us if you would like a copy of the trader's agreement to submit the dispute to ADR. Applications can be made with or without notice to the trader. For applications made without notice, where permission to enforce is granted by the court, the order will not permit enforcement until the trader has had at least 14 days from the date of service of the order to bring an application to set it aside. The 14-day time period is increased if the order is served outside of England and Wales. If the trader does apply to set aside the order, the award cannot be enforced until that particular issue is resolved. Once unconditional permission to enforce is granted, the consumer can proceed to enforce the order as if it were a court judgment. That means by applying for one of the usual methods of enforcing money orders, which include things like a charging order on property, a third-party debt order, or an attachment, not an attachment of earnings order in the case of a trader. The application for permission to enforce an award should generally be made on notice. If the application is made without notice, the court can require that the application is served on the other party if the court wishes to hear submissions from them. If an order is made giving permission to enforce following a without notice application, it must be served on the trader and cannot be enforced, as I have already covered, until the trader has an opportunity to respond. Alternatively, in some situations, a new action on the award may be required. A new action on the award may be required where, for example, the arbitration agreement was made orally, or where the consumer cannot produce evidence of an arbitration agreement, or there may be some other defect in the form or substance of the award, which puts the award outside the requirements of the Act. An action on the award is a new action to enforce the contract that is said to have arisen between the parties by virtue of an implied or express promise to pay the award made by the London Arbitration Centre. An application should normally be brought to the Central London County Courts, although an application can be made to the High Court or one of the district registries. Claims to enforce a domestic award must be brought within 6 years from the failure of one party to honour an award that is the same as orders of the court generally. Court fees. There's a court fee payable for an application or for permission to enforce an arbitration award. These are constantly changing. Therefore, please check with the court. Once permission has been granted, further court fees are payable in respect of the particular type of enforcement that is required. I hope this is helpful. If you need any more information, please do drop us an email and we will do our best to assist.